Right. Well, listen, good afternoon, everybody, and welcome to season seven, episode 6 of our Association Leadership webinar series. I'd like to welcome a warm welcome back to Alan Schwartzade and Jeff Rembaum from KBR Legal. Good afternoon, guys.
Good afternoon.
Afternoon, sir.
Thanks for joining, everyone. I just want to remind you before we get started that Jeff and Alan aren't here to give you specific advice regarding your association. They're here to just provide their opinions on the questions that we're going to tackle today. Many of you in the audience sent in questions with your registration. Some were very specific to your association and should probably be directed to your legal counsel, but I've tried to incorporate those that apply to a wider audience into the framework for today. We're going to lead off with actually some of the questions that you submitted. You can also, as Annabelle said, continue to chat in your questions, and we'll get to some of those during the kind of live question and answer section. We're going to lightly use the Zoom polling feature today, and we're going to start off with an easy question for you. And can we please post poll question number 1? What type of community do you live in? While you're doing that, today's agenda is a very short one. We're going to do a 2026 legislative update and ask Jeff to give us some highlights, and then we're going to go to Q&A. And again, I've pre-loaded several questions, and then we'll get to a live Q&A.
Craig, can we drop? Craig, can we?
What's that?
I was asking if we could please drop the meet the experts signage, but
Yep.
It just went away.
Okay. So let's post the results of the poll here and see what we have. Wow, 50-50, basically half the audience being HOAs, half being condos and co-ops, and several being what we now call 55 and better communities at Castle, since I turned 55 and better, as opposed to 55 and older. So we appreciate you all participating. So Jeff and Alan, full range for us today, which is good because our agenda is kind of split. Let's jump right into the 2026 legislative session. I guess, Jeff, I'd ask you, what happened?
Right, or lack thereof, right? We have
Yes.
no community
Finally.
association law. Finally, we get a break. Wow, it's going to be interesting. The condominium board members, as you know, and Alan will be discussing this in more detail, but they have their continuing education requirements each year, which the Division of Condominium has tied into a legal update, meaning the legislative update for us to teach the board members what happened, what's the new legislation. Except there is none this year. So I'll be real curious to see what the curriculum is going to be for their continuing education requirements. I'm going to drill into two of the bills, House Bill 657 and Senate Bill 1028, in a little more detail. I'm first going to cover some of the shorter bills that didn't pass. The reason we're going to talk about these is in all likelihood, they could rear again in next year's legislation. Some of it is good. Some of it is just frightening, literally frightening. It's the stuff horror movies are made out of. Can you imagine, as a little commercial to House Bill 657, if the HOA community just take a membership vote on a Sunday afternoon to terminate the HOA and the covenants are no longer in force and effect? Can you think about all the implications that happen along the way? For example, many HOAs are created simply because the water management district requires an operator over the entirety of the land comprising the HOA. Who's jumping into that responsibility? What if work has to be undertaken to maintain the drainage system? It was probably one of the most ill-conceived, draconian pieces of legislation affecting HOAs that I've seen in the 30 years of doing this. But that's just my little commercial before we talk about it. Let's talk about Senate Bill 1744, Official Records of Condominium Cooperative and HOAs. In short, this bill would have authorized audio-only conferencing for board meetings and membership meetings. A couple other changes, but that was the big one in Senate Bill 1744. In and of itself, okay, we can have audio-only meetings. Fine, it was legislating it. We have House Bill 1541, which was a companion bill specifically authorizing the audio conference meetings and requirements of how you have to keep them and post them, etc. Senate Bill 1498, affecting community associations, clarifying some common area definitions, electronic transmission updates, in other words, email updates, official record inspection refinements in favor of members, the definition of the term story, and things like that. Um, all these bills, some made it through the House, some died in committee. So there is no HOA dissolution law that passed. There is no statutory audio only meeting authority. We're going to talk, let's go into detail because there's a few more of these. Let's first talk about Senate Bill 1028, citizens. This is going to affect the condominiums out there. Citizens cannot write new policies if qualifying private market coverage is available. Citizens must provide the private insurers the opportunity to insure commercial risks before they can write new policies. So there's good and bad. What's the good in this bill? And then the good in this bill, had it passed, would have been more carrier competition, less risk for citizens, market stabilization. The bad, some associations are going to be pushed out to the surplus lines. There'll be higher deductibles, more underwriting scrutiny. In other words, the insurance company wanting to see so many more documents, condition of the roof, condition of reserves, your structural integrity reserves, and such. And now we will jump over and talk about, one second here, right? Okay. Okay, the biggest corpse on the battlefield. I love that. Alan, do me a favor while I'm going to discuss House Bill 657 and confirm, if you would, what happened with Senate Bill 1028. If you go to the Senate homepage, I would appreciate that.
All right.
Thanks, sir.
Citizen.
While you do that, I'm going to talk about House Bill 657. Everybody needs to pay attention to this one. This is the one where, I don't know where to begin. Let's start with Kaufman language. If you're drafting a new declaration, you had to have Kaufman language. What does that mean? It means simply a sentence in the declaration. This declaration is subject to Chapter 718 or 720, as the case may be. And here comes the Kaufman language as amended from time to time. As amended from time to time. It means as every piece of legislation that affects the declaration, regardless of what's in the declaration, you follow the law, not what's in your declaration. So if in your declaration it says the board has the right to do something, and you have Kaufman language, and then in the legislation, instead of the board, it's vested to the members, well, you're going to go in that direction. It means as every change is made in the law, even substantive changes, it applies to your association. That is dangerous. The declaration is a contract. It's a contract between the association and its members. We have constitutional protection against the government's interference in our existing contracts. And yet, here in this bill, the Florida legislature was about to decree, yes, the legislation can and it will interfere in your contractual relationship with your association. So much so that even for existing associations, the members were going to be required to take a vote whether to have broad-based Kaufman language applied to their declaration or not. It's just, what are they thinking in Tallahassee? It makes you wonder. Here we have next one. We have a legislator who's unhappy with her association. She works towards putting into the bill HOAs self-voluntarily terminate with an owner vote. That ended up in the bill. It went through the House and it passed, everybody. It passed the House. Thank God the Senate understood the gravity of this bill and the dangers, and it died in committee. But it could come back next year. This bill also, it eliminated pre-suit mediation. One of the best things to happen to HOAs, to keep HOAs out of court. Alan and I are both Supreme Court certified mediators. We mediate. We take our clients into mediation, not mediating on their behalf, of course, then we're representing them. But I have seen so many disputes get resolved at the pre-suit mediation stage. It works. Tell Tallahassee pre-suit mediation actually works. Can you imagine instead of having that opportunity, just suing all the lawyer? It's like a lawyer recovery act. It works to the benefit of the lawyers because if you don't have to go to pre-suit mediation, you can just file a lawsuit. Well, let the meter run because there's no telling when you go into a courtroom the amount of time, energy, effort, and all that equals money to the paying client. So pre-suit mediation, great way to resolve disputes. Not all the time, certainly worth the investment in it to give it a shot. It was going to create this bill. Circuit courts were going to create a community association court program to be funded by the DBPR. I'm sure the DBPR loved that impact on their budget. Minimum $2.1 million is the effect to do that. 2.1 mil coming out of DBPR. And there was also some new conflict of interest disclosure requirements for board members. Nothing much there, just a 14-day disclosure requirement if you fell into the conflict of interest. But the big things here, the takeaways was Kaufman language, forcing an association to have Kaufman language, voluntarily allowing the HOAs to self-terminate without thinking through all of the logistics and implications that arise from that. I've said it once, I've said it before, and I'll say it again. Sometimes some of the legislation that comes through, thank God we have people in Tallahassee that are lobbying and looking out for the interest of our Florida's community associations, because otherwise we're going to have the tail wagging the dog, the cerebral propensity of a lobotomized angleworm. That's what I think of the House Bill 657.
Alan, did you get a chance to look at that thing for Jeff? Are you good?
Oh, yeah, thank you for that. Alan, what did you find
did.
out on Senate Bill 1028?
So 1028 was ordered and enrolled by the Senate.
That's what I get. Yeah,
It's
I
been
thought I
adopted by
saw
both
that.
houses. I
Thank you.
don't see anything indicating that the governor signed off or his time to do so has
But it's
already
enrolled. But
passed.
it's enrolled, yes?
Yeah,
Okay,
it's
so
enrolled.
everybody, when you see a bill and it's enrolled, that means it has passed the House, it has passed the Senate, just waiting to come into law. I'll be surprised if this one doesn't come into law.
Agreed. And to clarify, that was the citizens bill for those not
Yes,
understanding what 1028 is. And
correct.
I think you put it very accurately, but I'm going to expand when it comes to this mandatory Kaufman language concept. I won't even
Oh,
bother
House Bill
touching,
657?
right.
Okay.
I won't even bother touching how incredibly I'm gonna skip the words
Draconian?
that are coming out of my head and not let them come out of my mouth. But the concept of this terminating HOAs more simply and easily, I'll skip that one altogether. But the concept of the legislature feeling that it's appropriate to say, I couldn't care less what the parties have contracted. Your declaration, your governing documents don't mean anything if we tell you we want it differently. Not we think it's right that it be different, but we've had enough constituents come to us and complain about their individual circumstances that we're going to let the 1% of the state that's going wrong impact the 99% of the state that's going right and completely ignore your contractual rights. You no longer have them.
Really well put.
Guys, let me ask you a question on the Kaufman language because there have been circumstances where there's been good legislation. So
Yeah,
if you don't have Kaufman language, you need to amend your documents to roll that type of thing in, or how would you address that?
Kaufman language really, after doing this for 30 years, there is a place for it on a case by case basis in certain places in the Declaration, not that every piece of legislation passed by the legislature should overwrite the governing documents. That's where you put that global sentence in the Declaration that is subject to 718. Chapter 718 as amended from time to time, as compared against in the collection foreclosure language in your declaration dealing with assessments, and it says only this chapter or this section is subject to changes in the law as they occur, right? Sometimes it makes sense for fining, for the collection foreclosure process, because you have to follow what the legislature says when it comes to collection foreclosure. It's a judicial process. We need the flexibility for the association to be able to easily adopt that new process when it comes out, if they tinker with it at all. So those are two areas where it often makes sense. Alan may have a couple as well, but we recommend that on fining, if you will, in case there's a change there, and we recommend a collection foreclosure. It's really about it. when it
Okay.
comes to that. So I hope that answered your question.
It does. It does. And I think the answer that was the question that was submitted. Okay, guys. Well, I think a couple things I'd like to add. One, it's been a nice reprieve for a year without major changes. Two, I think it's important for our listeners, you do and can and should get involved with this bad legislation when it comes up. And the more times, and everybody says, the more times email your rep and get involved, that it's really is helpful for us as an industry dealing with some of these, to your point, overreactions to, the vocal minority, which is, by the way, what happens in communities as well. So,
Sure does.
okay, well, Jeff, I appreciate that you just spent 10 minutes telling us that nothing happened. So, let's move on to
Listen, Craig, I found that extremely productive.
yeah, it was great. I want to move on, guys, to address the first kind of question that came in, and that is the board member certification and ongoing continuing education requirements in 24. For those of you who remember, they introduced a robust set of requirements for board members. The courses, by the way, it's so funny. They introduced it in 24, and Jeff and Alan explained to me when we were preparing that the courses weren't even available till the middle of 25. So we're basically a year in. There's a lot of confusion about what qualifies and what doesn't. So, Alan, can you just remind us? Let's start with condos. Remind us of the annual requirement, the board certification requirement, and the continuing education requirements for
Sure.
condo board members. Let's start with that.
All right, so for condos, you're looking at a 4-hour board certification class. This is the only one that actually says this is how long it needs to be. In an HOA, there's no specificity, but we're talking about condos, so let's go back to that. It's typically one session, at least the way we do it. It's split, hopefully, for the attorney's sake, among at least two people, because otherwise, talking for 4 hours, I think Jeff and my partner Mike Bender could probably do that without a problem. I know for me, once I'm talking for an hour, I need like a 5-minute break to get some water. But bottom line, it's a 4-hour session. It's a one time every 7 years class. Now, why the legislature decided that 7 years was the right time frame and simultaneously decided that you can't serve for more than 8 consecutive years, so you have to retake it and only have 1 year that's good for, can't say I understand the logic behind that one. My guess is someone that decided that this was good for 7 years didn't bother to look at the rest of the statute. But it's what we've got for now, so we just run with it. Now, the other continuing education requirement that applies to condos is a 1 hour legal update class. And as Jeff mentioned, no clue what the heck's going to go in there this year. He just spent 10 minutes, as Craig said, telling you everything that didn't pass this year. So my guess is DBPR will throw a bunch of stuff in that's tangentially related to condos and HOAs and management of community associations. And we'll pray that between me, Jeff, and a couple others within the firm, we can figure out what the heck to say about these things beyond here. We're going to read the presentation to you. Because I
One
don't know
thing,
that there's going to be a ton that goes in there that's actually relevant. Jeff?
Alan, we will make it. I know the way you lecture. I know the way I lecture. So if you happen to take either Alan's or my continuing education course for the condominium board member, we will keep it interesting for that hour,
Yeah,
regardless of
we'll
what we're
manage. It's
talking about.
just going to be a struggle for us, not for you guys. That's the way I'll put it. Good point, Jeff.
Guys, once I've taken the course, the certification course, and I get a document, what do I self-regulate? Does the DPBR regulate? Do I submit it anywhere? Like, what is the process?
So there are a couple different ways that goes. The first step is make sure it goes into the official records of the association. The fact that you have that certificate means absolutely zip from a legal standpoint. All it
Right.
means is that you took the class, congratulations. But what matters according to the statute is that the secretary has it or the manager has it, and it's part of the official records. So depending whether you have a managed community or not, that'll determine who puts it there, but it needs to be in the official records for it to count. Now, who enforces? Well, the statute kind of enforces it from a general standpoint. The statute basically says if you haven't done this, you haven't taken this board certification class, and this is regardless of whether you're in a condo or HOA. If you haven't done it within 90 days after being appointed or elected, you're suspended. It's not you can be suspended. This is like the legal distinction between something that's void, like it never happened, and voidable, where you get to elect, you get to choose whether it happened or not. This is the void. Okay, it's automatic. You are off the board. You can be replaced, But once you get that certificate with the secretary, again, not you just took it, but you get the certificate to the secretary or your manager and in the official records, then you're automatically put back on the board unless your term has ended during that period where you were off. Now, I don't know why DBPR would need to do anything with this because all you have to do is say this person's off. What DBPR would probably be more likely to regulate is if someone says, I don't care that I didn't take this class, I'm not going to stop voting as a director. Okay, that is something where someone's improperly voting as a director who technically isn't one right now might be something that DBPR or a court might get involved in. Jeff, you're scratching your head, and I don't know if that's confusion or just an itch.
That was just an itch.
Itch.
That
Okay,
was a legitimate
I
itch.
wanted to make
You're
sure.
overthinking, Alan. You're overthinking it.
Well, you've met me, so you know I tend to do
I
that.
do.
That's what makes me a good
Yeah.
lawyer
I'll
sometimes.
be careful.
It's a
I'll be more
competency.
careful for the rest of the session today,
Yeah.
not scratch
That's
anyone.
fine. Okay, so Alan, let's move. Thank you for that. Let's move on to
Sure.
HOAs now because that's more significantly changed.
It has. So, I mean, similar requirements, but a lot more of them. So, in an HOA, you've got obviously a board certification class. Now, that one, as I mentioned earlier, doesn't have a time restriction on it. So, the way we teach it is usually, depending on who's teaching and how verbose they happen to be, usually somewhere from 2 to 3 hours. I usually go around two and then a half hour of Q&A. Um, that is completely separate the way that we tend to teach it. Some people will ask us to do a joint condo and HOA class. That can be done, but I'm just going to be candid with you. Everyone that's in an HOA gets angry that we're teaching condo material, and everyone that's in a condo says, why do I care about HOA material? Even though they asked us to teach the class that way. So people complain that they feel like they're wasting their time. I don't want to feel like I'm wasting anyone's time. So we tend to teach those two separately, although we do have the ability to teach them jointly.
I won't
Um,
do it anymore. To your point, Alan, I will not teach the joint class anymore. It's unfair to the participants, and we're taking time away that we could be used for the HOA owners, and we're taking time away from the condo owners.
right.
So, yeah.
Yeah, I mean, the last thing I want is for someone who's getting a great education to feel like they wasted their time getting it. So,
Right.
I mean, I will 99.9% of the time say no, we're not doing the joint class. Now, when I will occasionally do it is if it's an in-person and I'm frankly doing a favor for some either a management firm who needed it for a group of 30 people and they don't care, or it's, the city of Orlando wants to put on a class. Those are really the only times I'll do it. I'm kind of on board with Jeff's suggestion of this just doesn't make sense.
Yep.
So
And go ahead.
I was just going to say, moving on, that is the board cert, and that in an HOA, it's every 4 years. So why we have the disparity there, I couldn't tell you, but we've got it, and here we are. And then you also have that continuing education requirement, and instead of 1 hour of legal updates, incredibly, you're not required to take a legal update at all in an HOA, but you do need what I call it's called continuing education in the statute. I call them elective classes. I think we've got 12 or 13 of them. And if you're in an HOA that's less than 2,500 lots, parcels, whatever you want to call them, you need four of those credits per year, 4 hours worth of classwork. If you're in a larger community, 2,500 lots or more, now you need 8 hours of classes. So that'll cover, some classes we offer are specific to HOAs. So HOA elections, HOA record keeping, HOA fines. And then we've got some of them that are a little bit more generic and will cover the HOA and condo slash co-op aspect, which are like the covenant enforcement. Jeff mentioned mediation. We've got a relatively new class that's specifically on that topic. I just put one together on weapons in community associations that will try and get certified so that we can teach it for HOA credit. But it's really across the board, and why the legislature thinks it's a good idea for HOA directors to have to know a little bit of everything and the condo directors to only need to know what's new and the HOA directors not to need to know what's new. I can't speak to the logic there, but it's
I
what
think
we've got.
you're going
And the
you're
fact that
thinking
the fact that
logically,
this
which is
education is
Well,
required at all, I'm just taking it as a win at this point.
and when you
yeah.
think about it, if you're in a condo, Chapter 718, you try to read Chapter 718, start
It's
to
only
finish.
130 pages or
Woo!
so. No
Is
big
that
deal.
all? And it takes there's so much more operationally to the condominium regime than there is to the HOA regime. It just makes you wonder why an HOA board member needs 4 hours or 8 if the community, meets the threshold, but a condo owner where they really could benefit from that extra time and that extra education is only 1 year. It just makes no sense. There's like the
Yeah.
left hand doesn't know what the right hand is doing up there.
It does. Well,
Well,
I
and
think, guys, I think the frustration I wanted to address, and Ness, can you pull up the KBR website? I think where we're hearing frustration is the types of things like the joint certification where it doesn't work for me, and why did I sign up for this condo class when it doesn't qualify? And then where are there HOA ones specific? And I think you guys have done a great job on your website. And for the benefit of our listeners, www.kbrlegal.com, I think is your website.
Sure.
But you can basically see exactly what you're qualifying for, whether they're continuing education courses for an HOA, for a condo, whether it's a legal update for an HOA or a condo. These are the types of things that you need to be able to go and see and do and listen in on.
And
So,
all our
uh,
classes are free. If they're on the calendar like that, they're absolutely free to attend.
yeah, and they're great courses for those who are listening.
now
We
let
do
me
appreciate
let
that you
me
doing that, and it does clarify for our audience what they need to do.
And let me clarify Jeff's point. It is free when anyone wants to attend online, but I do have some clients who will specifically say, I don't want to waste 8 hours a year trying to find these classes and forgetting I took one before, blah, blah, blah. So, for example, I've got one community in Daytona where every year, now this just started, so saying every year really means 2025 to 26, but every year they're going to have us come in and either via Zoom or in the community and just teach 4 classes in a row on one day, and they just call it their education day. And the board sits and listens to me gab and speak for 4 hours. I open up the Q&A throughout the entire presentation for these 4 classes, and we just do it twice a year, and then they're done. So that is a service we offer to clients. We'll charge for the time if we're specifically doing it for, and or I will. I can't speak for Jeff, but for existing clients. But for anyone that wants to attend, including existing clients, like Jeff said, these classes are free. Just attend online, and hopefully you get a lot out of it.
Yeah, I think that your strategies are good. In fact, we've managed a number of associations with masters and subs, and 500 unit community will have 30 board members, and as opposed to
Yeah.
everybody kind of trying to figure it all out, come on in, have a bagel, go through your training for a day, and plus I think it's good when everybody's together. You get to ask questions, and it becomes collaborative, and plus it can be very specific to your association, which I think is
Correct.
is very important because the courses that you're taking are very generic, but you can take the opportunity. You have your attorney in the room to ask them questions about your set of documents and your association and the nuances of your community. So,
The clients that
highly recommend that.
the clients that have paid for me to do the private board certification, where it's just that board and me, really do benefit because they get to have free flow conversation about their community during the time we are together. That we can play stump the lawyer, as I like to joke and call it, where they can pretty much ask anything as we're going through the material. And I do think there's a benefit to it. There's a cost, of course, but there's a benefit too.
Absolutely.
Well, I'll add, I
Okay.
think that the ability to not just go through a generic Q&A and we'll answer what the statutes and the case law provide under Florida law, but to be able to have me sitting there with your governing documents open and get you an answer to your specific question, even if it takes me a couple minutes to pull up the documents, find the right answer, and give you it's not just generic, it's here's what you can rely on. That is where we add significant value for clients who are having us do this in I'll call it a privileged setting, and allowing us to answer these specific questions about specific owners who we might have dealt with 50 times before, instead of just, well, here's your generic answer. It's right,
Absolutely.
but we might just say you
Yeah.
got to look at your governing documents.
And guys, I think I don't want to confuse our listeners. This is a positive thing. Education is a good thing for board members.
Yes.
So I think to the extent you look at it like a learning experience, you're on a board, you're volunteering your time. This is one more thing you have to do, but it serves our industry better when the board members are well informed and open to this type of training. Guys, I'm going to jump off from training now. Let's move on because we won't get to all these questions. I know we got a number of questions submitted with the registrations about amending your documents. And so, Jeff, I wondered if you could maybe share with us some of the keys for success for those associations that, have 30 or 40-year-old documents
Sure.
and are or newer and are thinking of amending them. Are there ways to make this happen that to make your likelihood of success better?
I think there are. I really do. First thing is, what's the requirement in the community to amend the governing documents? It's a membership vote. If it takes 90% of the community to amend the documents, or even 75%, that's a tough number. Many of our clients choose to educate their community that they're going to be amending and restating the entirety of their governing documents, declaration, articles, bylaws. And as part of that education process, they want to not just spend all that money on the lawyer for the documents not to get adopted. So the first vote, while we're working on the amended and restated documents, we do a simple, quick amendment for the board to offer to the members to lower that threshold vote to perhaps a majority of all of the members. I don't like a majority of a quorum. That lets the proverbial tail wag the dog, as they say, but a majority of everybody, somewhere between 50 and 60% seems to be of all votes, seems to be a nice number and achievable and attainable. So that's the first thing we do is let's set this project up for success. Then we need to talk about what we're going to amend in the documents. I prefer the client just have a free flow conversation or email conversation, as the case may be, with me. Just, hey, what's on your mind? Why do you want to do this project? You allow 2 dogs, you want to allow 4 dogs. You don't allow cats, you want to allow cats. Just tell me in plain English what's on your mind. We will go through the governing documents, and attorneys do this 2 different ways. One way is we can look at the documents and then write a big long letter, 30 pages long, telling you everything we would change and why we would change it and da 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 da, and then ask them to check off which ones they don't want. Otherwise, we'll go ahead and draft it in. I prefer not doing it that way. I prefer to have that conversation with our client, and then we go to work. And when we present a red line of the declaration, it's not just punch a button, right? There is no one pro forma set of governing documents. You want to keep the spirit of the community alive through using the existing declaration and amending the actual language that is in it. So it's custom for each association. It really does tend to work out better that way. And then when we deliver that first set, we deliver it with a full-blown explanation. And that's when you get your big opinion letter, if you will, telling you all the changes we made, why we changed it. For example, association maintenance and responsibility. Do we want to shift what the association is doing, what the owner is doing? When it comes to condominiums, have you adopted your what's the word I'm looking for, Alan? Hurricane protection
Specification.
specifications. Absolutely, because if you haven't, and the condominium has an issue, and the protection has to be removed on the outside, and you haven't made it in the declaration itself a owner responsibility, it's going to be an association fiscal responsibility. It was changed in the law a couple of years ago, so you need to think about amending that. What about approval, right? Who can live in our community? Not just we want to approve the owner, we want to approve everybody that's going to live in our community. If you're here greater than 30 days, you're no longer considered a guest. You're an occupant that needs to go through the approval process like anybody else. So those all the maintenance we just talked about. Do you want to limit the type of animals? Do you want to prohibit smoking and the common elements? We can talk about that and put that into the governing documents. So many things to think about. Alan, any other subjects come to mind?
Not necessarily any particular subjects. One that I always suggest considering is when you're talking about enforcement, making the costs that you're incurring, the fees you're incurring, and going through that enforcement process and assessment against that lot or unit is something that I think makes it easier for the board to justify, to the extent any justification is needed, well, we're going to go through counsel even though we have to spend the money to do that, and making it recoverable regardless of whether you have to file a lawsuit or not, at the time that either the violation's cured or you get a judgment and a judge says, yeah, you know what, that was a violation, without having to get a specific fee award. I know
Right,
there are
Alan.
concerns there, but go ahead, Jeff.
Oh, I'm sorry to interrupt. But let's drill into that a little bit. So, two different lawyers, maybe two different ways of seeing that situation. So, you're talking about amending the declaration, and I'll put it in plain English. In the event the association has to send a demand letter because your roof is dirty, you're going to get a bill if the lawyer had to send the letter. And that bill is automatically considered in this drafting language, automatically an assessment considered an assessment. So the board doesn't have to have a board meeting and notice and then levy the assessment. It's automatic as per the declaration.
Oh, see, I do it a little differently,
No,
Jeff.
I'm
I
just
do make
asking.
them have a meeting.
You do okay, fine. So they can then convert it. I like that too. We kind of call that an individual assessment. We follow the special assessment procedure. It's not really in the legislation, but if the board is going to affect the ledger that is going to be liened and you want it to be an assessment, you somehow, some way want the show the authority that that amount due had the ability to become an assessment. So, Alan, to your point, is it really worth it just to, we sent the demand letter, the owner came into compliance, and now we're going to thank him by giving him a bill for $400 for an hour of the attorney's time to have sent the demand letter to clean the roof. And now, do you see an association actually trying to foreclose a home because the owner says, I'm not paying that $400, and they leave that on the ledger, they don't pay it, but you'll get bounced out of court in New York second. You try to foreclose someone's home because they didn't pay for the attorney demand letter. So I'm not sure I feel quite the same way as you do on that, though I do think, to your point, it's a great enforcement tool. Hey, owner, if you don't do this and we have to use our lawyer, you're going to get the bill.
Guys, I would suggest that's probably the more, like, to your point, it's not the first letter, the first time you get your letter saying, please clean your roof. It's escalated, to the point where it's so frustrating that we had to engage someone else. But I think just to recap, I think with respect to amending documents or changing them, I think your strategy, just don't say, I need to amend my documents. What is the issue you're trying to address specifically, and amend it for that. The other thing I would say that really has helped in the success is when you use electronic voting.
Oh,
Back in the day, we used to send out the copies of it and all that stuff. And
right.
now that you have, I remember, I see you rolling your eyes, Jeff, because we probably lived that together. But now that you can do it electronically, you can continue to poke the residents who haven't voted so that you can, have likely have more success as opposed to just mailing it out, having a big count, not passing, doing it again. I think the electronic process has really helped people get amendments through their community.
And for notice as well. So when you're considering the electronic voting, also consider giving the members the opportunity to receive their official communications via email. And everything
Absolutely.
is so much more cost effective, easier,
Yeah.
simpler. Hey,
Yeah.
Craig, what about what Alan was talking about, the amending the governing documents to include provisions where if we have to use the lawyer, you homeowner have to pay for it. And from the manager's perspective, how often do you see that language? What do you see from that?
Not a lot. I would have to say we don't see that a lot. The fining process is well regulated, and violation process is well regulated. Usually you can get the items that need compliance, you can get to compliance. The bigger issue is the stuff that really can never be complied with, right? Like the paint color's wrong and you just kind of have to sit and wait and you put $1,000 fine on someone's ledger and you wait till they sell their home. I think that's where it would be really useful to help it, but we don't see it very much. We don't see it very much. Okay, well, I want to, before we move on, I want to bounce back for a second because, Alan, your presentation on hours required generated a whole bunch of questions. So let me read a couple of these for you if I can.
Sure.
For newly elected board members, do they need to certify before or after the election? So I get elected. Is that the trigger for me to have to go get certified?
That's the trigger. That doesn't mean you can't do it in advance if you choose to.
Okay. Okay. Great answer.
So I think you
If you
have, and Jeff, correct me if I'm wrong, you have up to a year beforehand to have taken the class and have it still count.
There's actually been a change in
Well,
the
there you go.
legislation, and I'll have to drill into it. It doesn't come up all that often, but if you really read the fine print, it seems like one of the acts is suggesting that they removed the ability to pre-certify. I don't think they did it on purpose. It was just the effect of the language in the amendment to the legislation itself. Alan, I think it might have been HOA. but it was one or the other. It took that 1 year, you can certify up to 1 year in advance language out of the legislation. Though if someone's certified, my gosh, you're certified. But then again, if you have a break in service, you have to recertify, right? So, unless you're a HOA appointed developer. So, if the developer in the HOA, when they appoint the developer controlled board, and those individuals already are certified, they don't have to recertify if, in fact, they're pulled from that board and moved to a different board and they had a break in service, let's say, of 2 weeks. But that's just, we're getting really into the
Yeah,
minutia here when we
I think
go into
that,
those
yeah.
fine points.
Let me ask you another one. If you did not take your CEU during the July to June timeframe, are you eligible to run for the election in the new year?
Huh?
If
What?
you did not take your CEUs, there's no demand period July to June, right?
No,
Well,
that's the first part, right? None.
So if you didn't take it, are you eligible to run for election in the new year? So the certification isn't a requirement to run, it's a
correct.
certification to
To
serve.
stay on the board. And
It's
Stay.
purely you're
good.
on the board, you need to be educated. If you're not on the board yet, you apparently don't need that education according to the legislature.
Right. No, that's just fair, I
Mhm.
think. Okay, let's move on to the next topic, guys, which is record requests. One of our favorites over here at Castle. The number of record requests just continues to escalate. In our world, there's lots of rules around it, but what I want to specifically ask you about is with respect to records requests, we always recommend the association have a policy to deal with them and address them. And I'm curious, actually, before I get that, let's post the poll question. Has your association adopted a formal policy for addressing record requests? So let's see what our team is answering out there. And then, Alan, I wouldn't, if you don't mind, do you make the same recommendation? And if you do,
Mm.
what would you see normally in that policy?
Well, I mean, the answer to whether I recommend having a records inspection policy is absolutely 100% yes. I mean, it's any policy that you enact, if you're drafting it properly, is to protect the association. And in this case, it happens to be protecting from those owners who send 25 records inspection requests in a month. That can govern, and I think the statute says the time frequency and duration of these records inspections. So that means how frequently they can submit the request, how long the board has to actually spend or management has to actually spend addressing each request, which can be anything up to 8 hours per month, according to the statute. You can't say it's got to be less than that, but you can split it up into separate instances and say, well, we have 3 hours today. You can come back tomorrow for your next 3 hours and come back the next day for the next two. But that just adds to the burden of the manager. And you can say, this is when you're going to do it. You can also, in my opinion, and it's not directly in the statute, but you can say, unless it's submitted in this particular manner, we are not accepting it. I know that there are some people that will say, no, you can't do that. I haven't personally seen any DBPR ruling or court decision that says you can't. I think it's reasonable to say you need to make it in this way and send it to this person. Otherwise, you sending 5 different emails to 5 different directors and yet another one during the same month to the manager and another one to the attorney is not an appropriate method of submitting these requests. So the goal is supposed to be to outline how you're going to receive them and how you're going to respond. The other thing I think should be in there, and the statute allows this as well, it can either be in the management contract or in this kind of policy, but what are you going to charge in order to produce these records? Now, you can't charge just to say, here you go, take a look, but you can charge for copies. 25 cents a page as a max, anything more than 25 pages. So that first 25, they're free. You can also charge for management's time to compile and go through all of this, anything in excess of 30 minutes. And
What
that's
about the
half of.
attorney? They're bringing their attorney, and the association wants you to be there, Alan. How are they going to get that cost back?
Well, there's nothing in the statute that says you can get it back. There's nothing in the statute that says you can't. But my perspective is, unless it's part of a dispute and the governing documents say you can get that money back, you can't. So if you want me to sit there and watch this person inspect the records, my perspective perspective is you're probably wasting your money.
It's
What you should
also a
do
cost of
instead, in
doing
my
business.
opinion,
It's a cost of doing business, is the way I look
right.
at it.
Well, that's one way to look at it too. My perspective is if you have something in this policy that says no answers will be given to questions that are raised either before, during, or after this inspection, then you don't need the attorney there because if the attorney, like Jeff mentioned, does show up, your response is not answering questions. Also, we have counsel, so you can't talk to me because you haven't been authorized to.
And there was a
The-
change in the law too, right? It used to say you could the member doing the record request or their authorized representative, and now
right
it's
now it's
and.
and.
So, right, yeah. So now they can bring the lawyer with them. I did
Right.
want to go back to one thing I said to clarify. I pulled my notes out on the minutia of board certification programs. And Alan, to your point, spot on. You were talking about how long it's valid for. And HOAs was 4 years, and the board cert was 7 years for the condo owners. I loved your point about the 8 year board limit of service, right? That was interesting and how that kicked in. But we were ending up our conversation with the pre 1 year. Can you certify 1 year in advance? And for HOAs, the answer is yes. And they removed that sentence from the Condominium Act in order to be able to pre certify, interestingly.
Thanks.
Okay.
Good stuff.
Thanks, Jeff.
Alan, I think that's guys, I think we do. Let's look at the results of the poll about whether or not you have or don't have a policy.
Well,
Well, you need a
Well, a
policy.
lot
You
with
better have
respect
one.
to, yeah,
Oh
I
no.
think guys, this is really, I think important to your point, Allison, a well-written Alan, a well-written policy, can protect the association. You nailed a bunch of different things. I think, people making record requests are looking for a debate sometimes, and it's a record request. It's an inspection of records, really. So you're not required to answer questions, and I think that's the debate we get into. So it looks like a huge opportunity for you, listeners out there who don't have a formal policy with respect to a records request. We highly recommend it, as I said, because it can get to be a big lift for your on-site
Wait
team.
until you need those rules adopted. You've waited too
Yeah,
long. That's
yeah,
that's when the
well,
association board wakes up, is when they start to get inundated by a cantankerous owner or a legitimately upset owner, either way.
yeah,
Yeah, it's good to have those, especially who can receive the official record request. You can specify it has to go to this address. But otherwise, if you're at a bar having a social event one night and a member walks up to you and hands you a request, it's written on a napkin, arguably, that triggers the request. You don't want that situation.
yeah.
well, and I'll
Okay.
I'll point out also, you
Go
had a
ahead.
bunch of people on that survey that said, I don't know. If you
Yeah,
don't know, here's your free reminder to go back to your manager, go back to whoever maintains the records and find out. And if you don't have one, to Jeff's point, now's the time to adopt one.
yeah. Excellent. Okay. We got a number of questions submitted around best practices for board members, and it kind of aligns with our discussion on the policy with respect to records inspections. I'm going to post a third poll question. What formal policies has your association adopted? And again, or you don't know, check them all. And then we're going to ask Alan to briefly take us through what his recommendation is when he's meeting with a new board, and what types of policies they should have to manage business. So let's give you a second to answer, and then Alan, I'll get you to do that, and then we'll go to some open Q&A. So I see people are still answering. This is
So
a
I'm going to
long
give everyone
question.
a
We
spoiler
apologize.
while they're answering. You should have
Yeah,
all of
Alan. Yeah,
them.
please,
You should
please.
have them all.
Yeah. So you should have them. That's good. That's good guidance. Let's go through maybe just the highlights of some of these. Let's post the
Sure.
poll, the response. It looks like everybody's answered. So let's have a look. Um,
Not bad.
can you see
Okay.
it now? So
Could be
record
better.
inspection. It looks like everybody's around 57 for collections, which makes sense. Covenant enforcement 44, 50 is the kind of the highest, but guys, there's a lot of opportunity out there to kind of formalize the way you conduct the business of the association. So, Alan, can you hit on a couple of these highlights if you don't mind?
Yeah, I mean, I'll just very, very briefly go through each one. I mean, records
Yeah.
inspections we just touched on, so I'm not going to waste your time duplicating that. Records retention was actually one that was added to the statute as being mandatory For condos, HOAs, and co-ops back in 2024, it basically says, here's how and where we're going to maintain our records. Here's what's going on our website. Here's what won't be on our website. And if we're going to dispose of records, here's how long we're going to wait to do that. Usually that's based on what's in the statutes. And here's how we're going to dispose of them. Are we going to just delete the files? Are we going to, shred whatever is on in paper form? What are we going to do when the time comes? So that's your retention policy. Jeff mentioned the hurricane protection specifications. That, by the way, is another one that a lot of people said either we don't have it or I don't know. Again, mandatory as of 2024. July 1st, 2024, both of these came into being statutorily required for all community associations in Florida. This is basically what is and is not allowed in your community by way of hurricane protection. Are you going to allow shutters? What are the specs? Are you going to allow hurricane protective windows and sliders? What are the specs for those? A lot of times, frankly, this just becomes, if you're in an HOA, part of your architectural restrictions, but you still need to have it, even if it's not a separate policy, in my opinion. Then you have your collection policy. I think you said that most people seem to have that. Frankly, most management firms we work with make that mandatory. And what this does is say, if you don't pay on time, here's when we'll start the collection process. Here's who's going to do which of these steps. You're going to owe interest and maybe late fees, depending what the governing documents say. Here's the interest rate. And if you don't pay by the time that our notices expire, you might have one courtesy notice, you might have a notice of late assessment. To the extent that that's still required by Florida law, it is now. Hopefully, at one point, it won't be. But, to the extent that's still required, are we going and moving to council for everything after that? Or is management or someone else sending the intent to lien letter? The goal of most of these policies, by the way, is just to automate the process. It's to take the burden off the board to screw it up, to be candid. It's to take the burden off the board to say, well, we like John down the hall or John down the road. We really don't want to go after him. There's a name for that in law. It's called selective enforcement. So, what these policies do, and I'll say the same thing about the covenant enforcement policy, which is what actions are we going to take when someone doesn't do what they're supposed to do with respect to the non monetary covenants in our community? If someone doesn't comply, we don't want the board to have to sit, wait for the next board meeting, decide whether to move forward in each step within the process, have the opportunity to selectively enforce, even inadvertently. And it's not just, well, we're going to go after John. It's going to be, oh, we forgot to go after this guy. Or, well, let's give him a little more time to comply because it looks like he might be trying, or he came to my house to ask for a little more time and we said it's okay. My perspective is you automate as many processes as you can, and these two are really good ones to automate to let management make the decision, to be uniform, be consistent, and have these things done in a timely manner. And the last two, member participation at meetings, same thing. You don't want to kick someone out and let someone else stay because they've overstayed their welcome and spoken for more than their allotted 3 minutes. This is the time, frequency, and duration of member speech. It's the how and when and where you can record, which is, by the way, any board or member meeting. But you put in your policy, you can't interfere with others' ability to observe the meeting. You're not shoving your phone in people's face like this. You're stably recording and getting a record of what was done and what was said. Your goal should not be to get in everyone's way and interrupt the meeting. And what happens when someone does interrupt that meeting? And then finally, and obviously, this is all very summary in nature, but the last one, disability related requests. What are the forms that people can fill out? Not that we're going to require any particular forms, but what's going to make it easiest for the board to review these ESA requests, the service animal requests, all the other things that come along with reasonable accommodations. We've got classes, by the way, on every single one of these topics, and they're all available, as Jeff mentioned, for free on our website. But the other thing that this disability related policy does is outlines the procedure of what can you look at, what can you ask, what is going to get you in trouble if you ask, as to any accommodation request that might be submitted by a member or anyone on their behalf. It's how do we protect the association? How do we protect ourselves from ourselves because we don't necessarily know when to reach out to the attorney. It's also going to outline you can't just assume that because they didn't use the word accommodation, that means they didn't request one. So lots more goes into that. As I mentioned, classes that we offer on every single one of these subjects. And what Jeff didn't mention, and I'll add, is I just sent one to a client today regarding this particular issue. We have recorded classes from the last, I don't know, 5 years or so. Those are all available for free online, although you can't get credit for taking the class just by watching a pre-recorded session. But the information is still there.
Can I dovetail into you, Alan? I want
Please
to.
do.
All right. I just pulled up a couple things. You talked about having a collection policy. In addition, this is all things for new boards to consider. Do you have it or not? And if not, fill the gap. Collection policy, electronic voting, opting in to receive official communications via email. To your point, rules regarding official record requests, official record retention policies as well. If you're a condominium, rules regarding certified written inquiries, rules governing, you talked about this, behavior at meetings for board members and members alike. And also, something new that I've recommended for new boards is have us prepare an annual meeting notice package so that the association board members are familiar with the election regime, especially for HOAs. I cannot emphasize enough how many times we have been brought in as HOA attorneys, and the manner in which that association is conducting their election was just because somebody pushed a button and out came forms, and they're not following the election regime in their governing documents. Alan, I see you shaking your head. I know you go through that too. And then we have to go to the board and say, what are you doing? And then try to educate them and teach them about their election regime. So I much rather we get in front of that. So that was just a few more to add to
Awesome.
your growing list.
Okay, guys, can we do let me go through some quick hits here. Our bylaws say certified letter is required for record requests. That's in your documents, or that is in your policy or bylaws. Can any other form of request be ignored?
Such as,
Meaning
Email.
it's not sent certified mail, it's sent via email. It's
Yep.
put on a napkin, as you mentioned, Jeff. And my perspective is,
Yep.
yeah, if we specifically said it needs to be submitted this way, that is an enforceable provision.
agreed.
I agree. I think I don't have a lot agree, but from a common sense standpoint, I think that makes sense. When you're adopting these policies, are you just adopting them as kind of rules, or do you need to amend the bylaws?
No, they're the same as a board made rule. And so unless it's something that impacts the use of the lots or units themselves, it's generally just 48 hours notice, regular board meeting, board votes and says, yes, we want this. Either you have a resolution or you have meeting minutes after that record when it was actually adopted. Now, for my office, I'm not going to speak for Jeff or any of the other offices within the firm. We put together a governing document book for every new client. That policy will then go into that governing document book once it's been adopted. So we're operating from the same set of documents that the manager is or the board is. And so
Absolutely. I'm
we
old fashioned. I
so
created a three-ring binder, Alan. Old
there you
fashioned
go.
three-ring binder, deck,
All right.
articles, bylaws, rules, regulations, and any other important document.
Yeah, so
I
we're
got
doing
a
the
whole
same thing, just
wall of
digital. Yeah,
yeah.
I have a whole folder instead of a wall.
Yeah, you electronic. Yeah, you're all I'm both actually, but I'm more physical. I like to turn the page of the declaration still. I'm old fashioned.
I do like to feel it. I do like to feel the book. I'm old school with you, Jeff. I think Alan's a young pup in this
I do
world.
read on
So,
my Kindle though, so that's
guys, a couple of questions on reserves.
serves.
Does the 718 require the reserves be done every 3 years is the question. Is there a requirement other than, I guess, let's talk about the SURS requirements, but is there a requirement for a general reserve study in the condo in 718?
I think this is probably coming from the shift to the insurance provision of
That's
the
what I was thinking.
Condominium Act that came out this year that says you
Right?
need a new inspection and to update and to
The
be
insurance
more specific,
appraisal
you need
every
an
3 years.
appraisal
Yeah,
every
Yep.
3 years to
yeah.
update that insurance coverage so that it's proper. But there's no need statutorily for a new reserve study to be done.
Only one. There is one need I can think of, not to correct you at all, but there is one, right? Because if in the condo, if you time your milestone with prior to, I'm doing this from memory, 2028, you have that 2 year gap, you can waive reserves, and then at the very dove end of the legislation, it requires an updated reserve study when you go back into the reserves after that waiving period is over. But other than that, Alan, I agree.
No, I
Well,
agree,
there's
Jeff.
a
Some of
SIRS
us respond to
requirement.
the question
There's a
asked, some of us go beyond. So good job.
there is a SIRS requirement though. A recurring SIRS requirement, isn't there?
Yes, that's every 10 years.
Every 10 years, yeah. I think we just recommend as a best practice, you're not engineers. Get it. We've always talked a lot in these webinars about, their engineer really becoming your partner, another partner along with your attorney management company these days. And it's good to go in eyes wide open, I think, when you're talking to residents about reserves. Have a professional do it so you're making good decisions, not based on someone's potential knowledge of how much it costs to do a roof these days. Um, Guys, that's really all we have for everybody out there. Thank you very much, Jeff and Alan. Always a treat.
Pleasure.
I learn a lot, so thank you for your time this afternoon. Guys, you can get the recording of this on our website www.castlegroup.com. I think you guys have it on kbrlegal.com as well
We
under
will.
resources. So we appreciate your time. We appreciate what you do in our industry, and we'll look forward to speaking with you again another month. Guys, thanks a lot.
Great. We appreciate
Thanks
you
for
and
having us.
everything Castle does.
Take care.
Absolutely.
Bye, everybody.